So, what's your take on the conclusions, the substance that have led to the removal of the CJ? And do you also join that argument that she's removed as CJ but not as a justice of the Supreme Court, as the letter from the presidency said, removed from both, and some have indicted that?
Thompson, standards are predetermined. They are not ad hoc. And so if we are going to hold our Chief Justice and justices of the Superior Court to standards, there should be a set standard which are predetermined or predefined. Thompson, what is stated misbehavior is still not known. Here is the case where I think that my colleagues have been confusing embezzlement and so on and so forth. How do you say this is embezzlement? In the case where the Chief Justice is not a spending officer, there's a procedure. She herself has to apply for funds to be disbursed to her. There's a procedure by which that application goes to. The people in the chain, right, have responded to audit query, and the auditors found the explanation acceptable. How do you call this embezzlement? By no stretch of imagination, you can't call this embezzlement. In any event, what is the procedure for determining impropriety of expenditure in the public sector? That procedure is the audit by the Auditor General. And the Auditor General found no wrong with this subsequent to the management explanation to the queries that were raised. And so where is the wrongdoing? What is the basis for this? In Baffour versus NTAC, it is clear, the law is clear. When an enactment makes provision for a procedure for taking a step, it is that procedure alone which should be complied with. And in the public space, it is the Auditor General whose work it is to establish propriety or otherwise of an expenditure. And so where is the wrongdoing? How does she commit an error for applying and going through procedure to obtain expenses? I think that the decision is so embarrassing, to say the least. And so, yes, let's hold our public office holders, let's hold our judges, let's hold our Chief Justice to a higher standard, but the standard ought to be defined. Now, in the case of the transfer, how do you say that a Chief Justice who has been given the discretion under our law to transfer cases, to allocate cases, to assign cases to a judge, commits an offense for doing so? How? And then you say that, look, I'm not surprised that they said that the transfer of the staff of the Judicial Service is contrary to Article 296, Clause A and B. Because they can't even point to an established regulation that frowns on the transfer. In the absence of a regulation that frowns on the transfer, how do you say that the exercise of that power is arbitrary, is unfair, is capricious?
They find, what shall I say? They don't say the mere transfer or the mere assignment. For example, when they brought in the petitioner himself and the cases he was involved in, you know, at a point, the petitioner had got the Supreme Court to prohibit, you know, Justice Stockton, who was not a Supreme Court judge then, to prohibit her from handling the petitioner's case. And then she becomes Chief Justice and still has to do the assignment because that's her job. And she does them, and they say that they find ways to say that the way she did the assignment is like she looked for favorable judges who give judgments the way she had also done against the petitioner. You know, that's how they weave it around.
So the findings of the committee is even an affront to judicial independence. The independence of judges to determine cases outside of any influence. Something when the CJ assigns a case to a judge, because of the independence nature of the judiciary, right, is expected to determine the case pursuant to his judicial oath without any influence or, any sort of pressure. And so if we don't have such confidence in judges and think that they can all be influenced, then where do we find ourselves? So the finding itself is an affront to judicial independence.
Okay, so now we have to be sure if there's a particular finding about this, about transfer of cases and assignment of cases, like Aikoto had cautioned earlier. But you see, as I sit here, I'm asking myself, I was asking Inu Safuseni questions, and she was nodding in agreement and speaking in agreement that, the way Charlotte Osei's process went. Do you remember how they vehemently protested, that process? But now, because it has happened the other way, he can use that to rationalize what has happened to the CJ.
Look, you see, I wouldn't want to do false equivalence. I don't want to do false equivalence. If Charlotte Osei was wrong yesterday, it doesn't make what the CJ has gone through right. We have to be careful. If it is scores they are settling, because they keep making reference to Charlotte Osei, if it is scores, let everybody know that we are settling scores. It looks like that is what they want to do. If it is scores that the MPP did it to Charlotte Osei, so we also want to do it to the Chief Justice, then we know it is score settling. But Samson, I don't want to engage in score settling.
Okay.
Samson, I want us to move on as a country where our democracy becomes stronger. Right? You see, everything points to the fact that what has happened is wrong. Mr. Ayukoyotu, my honorable senior, pointed to evidence that shows that the allegations have already been dealt with by the Auditor General in respect of the financial impropriety. Deliberately, they keep making reference to embezzlement. This cannot be embezzlement.
I don't think embezzlement is the word that has featured
anywhere.
It's financial impropriety. It's financial impropriety.
With the greatest respect, I use embezzlement as an example of criminal offenses that proceed from financial misappropriation.
Okay, okay. Thank you.
Then you compared apples with oranges. I'm saying that this is financial.
I did not bring it up this
Mami,
as a matter of something.
Mami, when you were speaking,
so Mami, please do let us.
This is financial impropriety.
Absolutely.
And the Auditor General is the institution. The Auditor General is the person mandated to deal with it. The Auditor General has dealt with it. Can this be a ground for the removal of the Chief Justice? Is the committee an audit committee? In any event, the committee, look, I agree with Mr.
So the committee didn't seek to do an audit. What they sought to do was to understand the policy, that was relied on.
The interruption has not allowed me to flow, and I don't think you've been fair to me in that regard. Please, let me put that on record.
I think when you misquote me and misassign things to me, I'm entitled to correct it. I did not accuse the CJ of embezzlement. I did not accuse the CJ of embezzlement. In response to a question whether she
remains
a judge, and I merely said ordinary citizens may be brought before the Supreme Court for embezzlement. I did not say the CJ had embezzled.
The president's power.
If you're going to quote me, please do me
Together with the Council of State.
Quoting me correctly.
Mami, thank you. Thank you for your intervention. You set the record straight in that regard. Nana, go on.
The president's power to look into this matter together with the Council of State was invoked by the petition. The committee's power to look into this was invoked by the president's determination of the existence of a prima facie case. And the president forwarded, supposedly, the prima facie case composition of the petition to the committee to look into it. That is where the committee's jurisdiction commenced. Now, instead of dealing with everything and reporting to the president, you have dealt with just one. And now you have told the president you are going to deal with the rest. How are you going to deal with the rest? That tells you the poor nature of the work that has been done by the committee.
So the statement by the committee, they say that they will report on the other two. I don't know whether the report means they are going to continue to sit on the other two.
That tells you the poor nature of it. It tells you that they didn't do a comprehensive work because the prima facie invoked their jurisdiction to deal with the prima facie part of the complaint before them. Now, we don't have a complete work, and they are going to report. Report how? Look, my brother, there's something we need to appreciate. People have said that, yes, the president has done a very good work because Article 146 has been complied with. Article 146 is not in isolation. Article 146, by implication, reference other provisions of our laws that must be complied with. Right? When it comes to prima facie determination, it is not in isolation. Prima facie is not defined in the Constitution. Okay. Prima facie is defined in the Evidence Act. It tells you the nature and effect of the prima facie. And so you cannot tick the box in Article 146 and not tick the box in the Evidence Act. Then when it comes to the hearing itself, you need to comply with the rules of evidence. The rules of fair hearing also in the Constitution, particularly Article 23 and 296 of the Constitution, were all these complied with. When the Chief Justice in the process feels aggrieved by one step or the other, she has every right to seek redress in court, which is why she went to court under Article 1, Clause 2 of the Constitution.
Okay.
You see, Samson, when the Chief Justice invokes the jurisdiction, the human rights jurisdiction of our court, and she's told that the court doesn't have jurisdiction, Samson, when you put all these things together, will you say the Chief Justice has been granted justice? No, the whole system was very unfair to her, and my concern is going forward. We are done with this. I think that we should be very interested in building a stronger constitution.
All right. Thank you. Thank you, Nana.